when the judgment of the court is ready. And it goes like this.
As the court pleases.
The claimant commenced this action via a general form of complaint dated and filed on 22nd day of February 2018, which was amended on the 17th day of October 2019, wherein the claimant pressed the Honorable Court for the following relief with A. Personal injury at work. B. 3 million naira for shock, pains, and suffering. C. 1.5 million for medical expenses. D. 3.5 million for future ongoing medical expenses, and 700,000 naira for physical and mental agony. There is also the claim for wrongful termination of appointment. There is also claim for damages for professional fees. The claimant testified in proof of his case as CW1. He also tendered documents which were admitted in evidence. The defendants also called two witnesses who testified as DW1 and DW2. They also tendered several documents in evidence. After the close of case, the counsel for the defendant, KS Oloni Shola, cross-examined the claimant, while the counsel for the claimant also cross-examined DW1 and DW2, that is Mr. STNJ Esquire. I have captured the facts of the case. I shall omit that portion. I have also captured the submissions of the defendant, wherein they formulated two issues for determinations. They are all captured in the body of the judgment. I will skip it because of time. The claimant also formulated a single issue for determination and subdivided it into two. The argument of counsel have been captured in the body of the judgment. So I shall go straight away to the decision of the court. This is the decision of the court. I have carefully considered the originating process commencing this suit, the response of the defendant, as well as the evidence adduced before the court in proof and in defense of the claim before the court. I have equally perused the written addresses of counsel for both sides and listened attentively to submissions of the counsel for the defendant, Mr. Olori Shola, as counsel of the defendant as counsel for the claimant did not appear on the day when the final written addresses were adopted. A resume of the facts that led to the filing of this case, as can be gathered from the processes filed before the court, are that the claimant was an employee of the defendant on yearly renewable contract. This is depicted in Exhibit CW1, CW1D, and CW1F1 to 10. However, by the Exhibit CW1E, the claimant's employment in the defendant was terminated with effect from 1st of March 2017. The ground for termination was that the claimant was captured or was caught on CCTV camera cutting copper wire from one of the ACs and leaving the building with it. Equal to the termination of the claimant's employment by the defendant, the claimant instituted this action to claim for compensation for injury which he allegedly sustained in March 2015 while working on electrical appliances for the student, following the directives of the the Director Technical, Mr. Turan Benzil, where he instantly fell from a phone and sustained various degrees of injury. It is the case of the claimant that while he was working on the AC, staff of the defendant who were occupying the building recklessly defied the claimant's warning and put on the AC, and he was electrocuted and consequently fell on the floor. The claimant stated that he immediately reported the director on the same on the incident on 28th day of March 2018, who said he will discuss with the registrar of the defendant and get back to him. But no action was taken thereafter to assist him. He was left in pain and suffering arising from the electrocution and physical injury sustained as a result of the sudden fall from the ladder. The claimant stated that towards the end of April 2015, because of the consistent headache and shock, he decided to go to Primus International Super Specialty Hospital, where he was assisted medically out of compassion and had CT scan of his brain from the said hospital. He is CW1A and CW1B. The claimant stated that he borrowed 500,000 naira from a friend in 2015 for the treatment of injuries arising from the accident at work, but could not continue because medical charges were beyond the money he could afford. Following his medical injury in January 2017, he will require the sum of 3.5 million for his medical treatment to be able to recover from the shock which precipitated the occurrence of the headache pain. On the claim for wrongful termination, the claimant stated that on 27th day of February 2017, he was directed by his director, Mr. Turan Delgis, to carry out some repair on the air conditioner, and he carried out the work and has has some copper wires that were generating the problem because the wire became bad. The claimant stated that he cut the copper wire and kept them in store. He also stated while working on the AC, a security guard of the defendant was present, and the defendant's CCTV camera could assist to verify this. To his greatest surprise, on 28th day of February 2017, he received a CWNA letter of terminating his appointment with the defendant. He stated that the termination of his employment was malicious and against the terms and conditions of service, and that there was no query issued to him. In reply, the defendant, in their statement of defense, claimed that the defendant maintained that he was the defendant denied the claim of the claimant and admitted that the claimant was a former employee whose appointment was lawfully terminated by the defendant after the claimant was caught stealing electrical copper wires from one of the defendant's air conditioners, which act violates the constitution of which violate and constitute an act of gross misconduct, which led to eventual termination of his appointment. The claimant admitted cutting copper wires and taking it away. See Exhibit DWE. The defendant stated that it never received any report of any accident at work involving the claimant while claimant was under its employment. The defendant also stated that it never caused any kind of injury, whether directly or indirectly, during or after termination of claimant's employment, which is needed to compensate the claimant. The claimant was employed and worked throughout the period he worked for the defendant as technician and no more. The defendant insisted that claimant was never asked to climb any pole, either within or outside the defendant premises, as that job role is not within the claimant's scope of duty, but for electricians. It was stated all the staff in the technical department had been properly orientated on all necessary safety measures to be observed. The alleged incident never occurred, and for that reason, the claimant did not have reason for any medical attention. According to the defendant, all the allegations of medical treatment and certification are mere concoction and fabrication of facts to make a fictitious case. The defendant formulated two issues for determination, while the claimant formulated one issue which was never subdivided into two. In the final written address, The claimant raised an objection to the defendant's amended statement of defense and its accompanying process. The ground of the objection centered on alleged non-indication of who signed the amended statement of defense. According to counsel, according to counsel, the non-speaking of the name of counsel that fronts the amended statement of defense is fatal and renders the amended statement of defense incompetent and liable to be struck out. Counsel further argued that they were incompetent to file without leave of court and that the purported adoption of same is not of no moment as the complaint as the competent depositions were abandoned without any explanation whatsoever, even though all the witnesses admitted that they filed missing depositions. In response to the preliminary objection, the counsel for the defendant have answered the question in the affirmative. Counsel were relying on provisions of Order 26, Rule 1, 2, 4, and 5 of the National Industrial Code Code Procedure Rules 2017 submitted that rules of court allow parties to amend their process before counsel submitted the defendant has not done anything out of the ordinary. The statement of defense is competent and liable to be relied on. Counsel submitted that the submission that no leave of court was obtained to file written statement on oath of witnesses is misconceived. The rules of court are clear and unambiguous. There was no additional statement on oath that was filed or to be filed. On the 13th day of October 2020, KS Olol Nishola Esquire Counsel for the defendant moved motion for amendment of the defendant's statement of defense. The amendment was opposed by Mr. S.P. Yenge Esquire, counsel for the claimant, on the ground that the motion for amendment is incompetent and that the proposed amended statement of defense is incurably bad in that it has not been signed by a non-legal practitioner pursuant to Section 2, Rule 24 of the Legal Practitioners Act. The court, after listening to submissions of counsel, overrules the objection. It is interesting to note that the issue of signing of amended statement of defense has been dealt with by this court in the ruling overruling the objection in the ruling of 13th day of October 2020. And this court is bound by the said ruling. It cannot therefore reopen argument or revisit its own ruling, as the court has already found that the said amended statement of the same was duly signed by a non-legal practitioner. The law is well grounded that an issue already dealt with by a court in a previous decision cannot be brought again before the court for reconsideration. This court, having decided on the issue of signing of statement of defense by a non-counsel, the counsel for the claimant is stopped from raising the said issue again in this court. The only option open to counsel is to appeal to the Court of Appeal, which has not been done, as it is only the appeal court can reverse the decision of 13th day of October 2020. This court lacks jurisdiction to reconsider the issue, as this court is functions official insofar as that issue is concerned. The claimant in this case is stopped from litigating the said issue, and any attempt to revisit such decision issues in issue inevitably amount to this court sitting on appeal irrespective of its own decision. To buttress the point being made, reliance was placed on the cases of MT Delma versus MT Ane 2016, All Federation Criminal Report Part 383, Part 836, page 552. See also the case of NDIC versus SDN PLC, reported in 2003, 1 Nigerian Criminal Report Part 1801, page 311. And in Ayo versus Exenyong, reported in 2012, 11 Nigerian Criminal Report Part 1311, page 316 as 318. The Court of Appeal held that a court or tribunal cannot sit on appeal over decision or orders of a court or a tribunal of coordinate jurisdiction. This position was reiterated in the case of Lasisi versus Salau. The decision of this court on the issue of signing of a by unknown counsel remains valid and sufficient until it is reversed by a superior court on appeal. See the case of Cole versus Jubono and others reported in 2016 LCELR 40662SC. The grounds of objection to the witness statement on oath has no basis. The law requires statement of defense to be accompanied by witness statement on oath. The witness statement on oath of the defendant's witnesses attached to the statement of defense were properly before the court. Since there are no additional witnesses statement on oath, therefore, Order 3, Rules 14 and 15 are not is not applicable to the grant of amendment to statement of defense, including all the accompanying processes and the witness statement on oath being part and parcel of the amendment of defense. The witness statement on oath were properly before the court. On the whole, the objection to amendment of statement of defense and the witness statement on oath is misconceived, it lacks merit, and same is hereby discounted. I shall now turn to the main claim of the claimant. The claim of the claimant can be categorized into two. The first is claim on personal injury at work, and the second is claim for wrongful termination of employment. The claim of the claimant on personal injury comprises of claim for shock, pain, suffering medical expenses, claim for future ongoing medical expenses, and for physical and mental agony, stress, discomfort, and inconvenience. According to the claimant, the argument in support of these claims are, are contained in paragraphs 1, 2, 3, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 16, 17, 18, 19, 20, 21, 23, 24, 25, 26, 27 to 45 to 46 of the amended statement of facts. These amendments were repeated in the witness statement on oath. Counsel also placed reliance on exhibit CW1A, CW1B, CW1C, CW1, CW1D, CW1F, CW1G1 to 18, and CW1S. It is argued for the claimant that these amendments and exhibits tendered by the claimant in the course of trial have established entitlement of the claimant to the relief due sought. According to counsel, the contents of exhibit were neither challenged nor discredited under cross-examination by the defendant. It is further argued that the evidence in paragraphs of the amended statement of facts and witness statement on oath remains unchallenged and uncontradicted as CW1 was not taken under cross-examination. Counsel maintains that the claimant sustained personal injury while working for the defendant and that his job as AC technician and electrician that he reported to his boss by refusing but refused to treat him. It submitted that none of the witnesses that testified for the defendant was eyewitness. It was also argued that the defendant did not call Mr. Turan Denzil, the security man mentioned by the claimant as the person who gave him directive to refute because their testimony would have been would have favored claimant. It is also argued for the claimant that the evidence before the court and exhibit tendered have proved medical expenses as exhibit CW1A and CW1B were not discredited. Counsel argued that from evidence before the court, the claimant has established his case and entitled to judgment. The defendant on his part has contended that the evidence in CW1A and CW1B received and medical certificate respectively from Primus International Super Specialty Hospital and exhibit CW1G1 to 18, letter from the claimant solicitor chief ST Yange and Co. On a cursory look will show that exhibit CW1A, the receipt of payment of brain scan, which the claimant claimed to have carried out after electrocution, is dated 30th day of April 2015. And in paragraph 9 of the amended statement of facts and paragraph 11 of the witness statement on oath, the claimant stated that the date of the accident to be 28th day of March 2018, the period at which the claimant was no longer in the employment of the defendant, because Exhibit CW1E, the letter of termination of appointment, had terminated the claimant's employment. It stated that giving the fact stated in paragraph 9 of the amended statement of facts and paragraph 11 of the witness statement of oath are typographical errors. The said receipt was never presented to the defendant until when it was attached to Exhibit CW1G1 to 18, about 2.5 years of termination of employment. It is submitted that the claimant making this claim at this time is out of vindictiveness for the simple fact that the defendant terminated claimant's employment. There was also no formal report made by the claimant to the defendant all these years, and the claimant had been doing his work without any complaint. It is further submitted that Exhibit CW1B, the letter of medical certificate, which is not a medical report itself, but a letter to the defendant asking for assistance on behalf of the claimant. The letter itself did not state that the brain scan allegedly carried out by the claimant revealed normal findings, which shows that even if claimant had any such accident, which is not considered, it was not as serious as the claimant is presenting it. The claimant has not shown how he was affected by the accident. According to counsel, since the claimant was compelled to work the next day and did work, goes to show alleged goes to show that the alleged accident did not affect the claimant to deprive him of the ability to work until death. It is further submitted that claimant has nothing before the court to show that while in the service of the defendant, he did notify the defendant of any accident. As pointed out earlier in this judgment, the claimant's claim is twofold. The first set of claims borders on general and special damages for injuries sustained in the course of employment. The claim was predicated on alleged instructions or directives given to the defendant by one Turan Desville, the Director Technical Department of the defendant. According to the claimant, after climbing falls and while working on AC, the occupants of the building he was working on defied his warning and defied his warning to them not to switch on the AC, but they ignored the warning and went ahead to switch on the AC, which resulted in his electrocution. The claimant stated that he reported the matter to Mr. Denzel, who promised to do something. But when such assistance was not forthcoming, the claimant has to resort to borrowing money to treat himself. Let me state here that the position of the law is that in an employment relationship of this kind, master and servant at common law, the employer master is enjoined by the law to ensure all necessary safety measures protection of employee against any injury in the course of performance of his duty. Where the employer or master fails in its duty of making provision for safety materials to employees, the employee the employer will be liable to compensate the employee in an event of an employee suffering from any injury caused to him in the course of performance of his duty. In the case at hand, claimant insisted on being entitled to relief being sought, while the defendant is maintaining that the claimant has not, by preponderance of evidence, proved entitlement to the relief being sought. Now, it is up to consider whether the claimant has, by the evidence adduced before the court, proved his entitlement to the relief being sought. It is clear from exhibit CW1F1 to 10, CW1C, CW1D that the claimant was employed to work as the technical department of the defendant. The claimant started working with the defendant as an assistant AC technician with effect from 1st June 2013. The claimant's appointment was by letter dated 15th day of October 2014 renewed as electrical technician, see Exhibit CW1F1 to 10 by the Exhibit CW1C dated since the appointment of the claimant was renewed as a full-time member of the university administrative body, staff body. The appointment of the claimant was further renewed as an electrician by the CW1D when there was no evidence to show that the claimant is an electrician. Let me say that the master servant relationship at common law, employee may sue employer for compensation for injury at work, either in total or contract. See AFRAP 10 versus pharmacist, pharmacist award waiving. The claim of the claimant in the case at hand is in contract. There is no dispute, as shown above, that the claimant was employee of the defendant. The employer-employee relationship exists by virtue of the claimant's employment with the defendant. This means the claimant is bound to take instructions from the defendant, and in the absence of any express term, there is an inherent and implied duty imposed on the employer to take reasonable care to ensure the safety of employees in a master and servant relationship. This means that the submissions of the defendant that liability regarding health or medical treatment is as shown in the letter of renewal CW1 CWD is misconceived. The position found support in the Supreme Court decision in Ere versus Vendel Fees and Flour Mills Limited, reported in 2009, All Federation Kilo Report, Part 4, 453, page 1217. The duty of master is the same as that of employers, common law duty of care in the law of negligence, and the duty of an employer toward his servant is to take reasonable care for his servant safety in all the circumstances of the case. This clearly means that whether the claimant is AC technician or electrician, the employer defendant has the duty of taking reasonable care of the claimant while in the service of the defendant. The defendant in the case categorically denied the claim of the claimant on the ground that no any such injury has happened to the claimant, and even if it happens, claimant has not reported the accident to the defendant until after termination of his appointment, which according to the defendant, the claimant wants to rip off the defendant. The claimant maintains that injury occurred and the law of proof is well settled that he who asserts has the burden of establishing the assertion. The claimant is one who claiming that he reported the incident. In the circumstances, the onus is on the claimant to establish his position. Assertion. CUAC Nigeria Limited versus Joseph Oreka. In any event, in a claim for compensation for injury, the claimant must establish or fulfill certain conditions for him to be entitled to claim for injury. In the course of employment, these conditions are the law requires claimant to show that the employer has a duty of care owed to the worker. An accident has occurred. The accident was caused because employer failed to exercise the duty of care. 4. The accident caused personal injury to the employee. As pointed out earlier, the duty of care may either be contractual or delictal in character, and that the claimant is at liberty to sue either for breach of the contract or for negligence. In the case at hand, claimant choose to sue for the duty of care in contract law. The establishment of contractual relationship of the master and servant under the common law between claimant and the defendant has satisfied the requirement showing existence of duty of reasonable care. This means the patient to provide safety in equipment. E. Wilson. I'm sorry, I was having interruption. I'll continue from where I stopped. Now, having regard to the given fact, in this case, what this code is to determine, what this code is to determine is whether the claimant suffered injury and the injury arose out of the claimant's employment with the defendant. The defendant has insisted there was no injury, while the claimant insisted that there is injury. In support of his claim, the claimant tendered exhibit CW1A, CW1B, receipt for brain scan, a letter addressed to the registrar of the defendant informing the registrar that the claimant had reported at the hospital on 30th day of April 2016 with 1 month history of persistent headache post-electric shock. The letter stated that the claimant was evaluated clinically and advised CT scan on the brain, which revealed normal findings, and patient was managed conservatively on outpatient basis. However, the claimant could not continue clinic visits on financial grounds. On 18th day of March 2020, when HBCW1B was admitted in evidence, after overruling objection to the admissibility, I indicated that appropriate evidential weight will be attached to the document at the stage of writing judgment. For HBCW1A, let me straight away say that it is a receipt showing payment of 30,000 naira being payment of CT scan brain. It is no proof that an accident occurred at the workplace where the claimant sustained injury. For exhibit CW1B, this document is addressed to the registrar of the defendant. However, it was tendered in evidence, but the original was tendered in evidence. The original was tendered in evidence by the claimant, who was not the maker and to whom it was not addressed. How the claimant came about this document remained a mystery, as this code was not told. It is also it was really it was it was really issued by Primus Hospital to the registrar of the defendant. Why such an original document, not photocopy or certified true copy, be in custody of the claimant and not in custody of the person to whom it was addressed, i.e., the registrar of the defendant? In view of the absence of any explanation from the claimant as to why the document is not with the registrar, no evidential value can be attached to such an exhibit, and it is hereby exhibit CW1B is hereby discountenanced for the purpose of this judgment. Even if exhibit CW1B is to be considered in this judgment, the court is of no assistance to establishing serious nature of the injury the claimant portrayed in his pleading. The claimant abandoned that sometimes in March 2015, while working on electrical appliances for the defendant, following directives of his director, Mr. Denzil, staff of the defendant, in disregard of the claimant's safety, turned on air conditioners, which resulted in the electrocution of the claimant, who fell from the electric pole to sustain serious physical injury of varying degree, is not supported of by any is not supported by exhibit CW1B. This is because the document shows that the claimant evaluation at the hospital revealed normal findings. That has gone to show that the claimant's injury was not as serious as you want the court to believe. It is the case of the claimant that he reported the incident to Mr. Denzil, but no action was taken to assist him medically in alleviating the excruciating pain he was going through as a result of shock and hit his head against the wall following electrocution. Consequently, he went to a clinic in Abuja for his aid and consequent treatment because of shock and agonizing pain he felt in the body, particularly the constant headache. This assertion has not been proved by the claimant in that he failed or neglected to mention the cleaning he attended immediately after the incident, and there was no medical report tendered by the claimant in proof of his allegation of serious injury sustained in the course of performing of his duty. And I'm sorry, I'm waiting for Jen. The claimant has also stated that in April 2016, he went to Primus International Super Specialty Hospital where he did scan on his brain and received necessary medical assistance. The claimant further stated that he was unable to receive full medical treatment because the, the, the dependent has carelessly refused to assist him financially. There is no evidence adduced. There is no evidence adduced by the claimant to establish there is no evidence adduced by the claimant to establish that he reported the incident to the defendant and nothing was done. The onus of proof is on the claimant in view of denial by the defendant of the happening of the incident. The first time the purported incident was brought to the attention of the defendant was by the CW1G1 to 18, a letter from the claimant solicitors that was over 2 years the claimant after the claimant has after the claimant's employment has been terminated. The CW1G1 to 18 cannot serve as a proof of claimant's claim. All that this exhibit could do is to show that demand has been made by the claimant to the defendant only. The claimant has also stated that in 2015 he borrowed money in the sum of 500,000 from a friend for treatment of injuries arising from the accident, but could not continue because of medical charges were beyond the money he could collect. He could collect. The claimant further stated that he needed 3.5 million for further medical consultancy services to be able to recover from the electric shock. The claimant also stated that with the help of friends, he paid 1.5 million, 1.5 million for medical for medical treatment. There is no doubt that these monetary claims on, on treatment and the money needed for further medical treatment so as to recover from the shock are all claims for special damages for injury he allegedly sustained in the course of his work. However, there is no cogent credible evidence to establish the claim, as the claimant has not disclosed the names of the clinic hospital which he claimed to have attended before visiting Primus International Specialist. There is also no any iota of evidence to show that the claimant has attended any hospital for any first aid treatment. The claimant has also not disclosed the names of the friends that borrowed him money. He has also failed to establish the treatment he required, as there was no medical report showing what treatment he is to undergo that will get the sum of 3.5 million. The claimant has also not told this court the, the kind of injury sustained, nor tender receipt of treatment undertaken with the money he borrowed. The claimant should have known that his monetary claim is for special damages, which by law is to strictly prove and establish on the strength of his own case and not on absence of denial, more particularly when the defendant has categorically refuted the occurrence of the incident. See, Clifford's case. From the evidence adduced, the claimant has failed to establish that an accident has occurred in the course of employment of the defendant and he suffered an injury to which he could be compensated. It is certain law that it is not every injury suffered by an employee during the period of employment that entitles the employee to damages or compensation. It is only the injury suffered out and in the course of employment of the claimant, employment of the employer that will be that in the course of employment that the employer will be liable. The press out of and in the course of employment as used interchangeably in the sense that the accident or injury must have occurred not only during employment but must occur out of and in the course of the employment. In effect, the employment must be the cause of injury and the injury must have occurred in relation to the employment or incidence of the employment. See abstract claim versus pharmacist or douanier, there must be some causal relationship between injury sustained and the employment. Thus, an injury must arise out of and in the course of employment. Any injury sustained by employee which occurs by a mere coincidence to the occurrence of the employment cannot be an injury arising out of and in the course of employment. An injury suffered by an employee for whom the employer would be liable to may include any harm to the health of an employee either by accident or by disease, which arises in the course of out of employment incapable of whole part. That the defendant owes the personal obligation to the claimant the requirement of duty of care. It is my view that in the circumstances of this case, the claimant has not suffered any injury in the course of employment to be entitled to compensation. I hold without any hesitation that the claimant has not proved his claim justifying payment of compensation for the purpose of injury sustained. This finding means that the claimant is not entitled to compensation for damages. Consequently, this issue is resolved in favor of the defendant. I now turn to the issue of termination of appointment. The claimant hinged his claim for wrongful termination or lack of notice of fair hearing, while the defendant insisted the claimant admitted cutting copper wire from AC and he apologized for his actions. See exhibit DWC, Mr. Turan Denzil, to carry out repair work. The relevant fact on the issue of wrongful termination is to the effect that on 22nd day of on 27th day of February 2017, the claimant was directed by his director to repair his air conditioner. The claimant carried out the repairs and had some copper wires cut, cut out from the cut out that were generating heat because the wires were bad. That he kept the wires in the store of the technical department. That while he was working, security guard was there. On 28th day of February 2017, the claimant received letter of termination of appointment on allegations that he cut copper wires and took them away. The law is well settled that an employer under the common law has the right to do away with employee for misconduct or on good cause on good cause shown. The employer is also entitled to state reasons or give no reason for termination. However, where reasons were given, the defendant has the duty of justifying the reason for the termination. Exhibit CW1E, the letter of termination is very clear on the reason for termination, that is cutting copper wire from AC belonging to the defendant. Exhibit GWC clearly shows that the claimant has admitted in writing of the act which led to the termination of his appointment. The claimant is now raising coercion that the content of Exhibit GWC was dictated to him by the chief security officer of the defendant. It is to be noted that the claimant in his pleading in the amended statement of fact never raised the issue of coercion or even alluded to the fact of the writing of statement containing the admission until when the defendant filed defense and raised the issue. It was in reply that the claimant came up with the issue of coercion. I do not believe the story of the claimant that there is any coercion. If there was such coercion, such incident should have been raised in the pleading and not coming as a response. In any event, the pleading and evidence of the claimant before the court has admitted the facts contained in the letter of admission. Furthermore, it is the claimant that is claiming he was coerced, so the onus is on him to establish the assertion. The claimant has admitted cutting copper wires and keeping it in store, but there was no evidence to show that the copper wires were cut by the copper wires which were cut by the claimant was actually kept in the store. The claimant having admitted misconducting himself, the defendant is entitled to summarily terminate his appointment without much ado. This termination is valid. The claimant has made a claim of pay off on termination. The defendant has argued that the claimant having his employment terminated has no right to claim any entitlement. The law is settled upon termination of employee is entitled to claim his entitlement. It is dismissal that has the effect of denying or making employee lose his right to make claims except those earned before dismissal. In our labor jurisprudence, distinction exists between termination and dismissal. They are two different things. An employee an employee whose appointment was terminated is entitled to make any claim for any benefit that he is entitled to while in the employment of the dependent before losing his employment. In the case at hand, what happened was claimant's employment with the defendant was terminated. This means that claimant can make all legitimate claims based on termination of his employment. In one brief, the claimant stated that his employment with the defendant is for a period of 1 year, renewable, while in another brief, he stated that he served the defendant for over 3 years. A careful preparation of CW1C, CW1D, and CW1G118 will reveal that the initial appointment of the claimant was meant to be for 1 year, but the subsequent renewal has changed the employment of the claimant to that of a full staff. This means the employment of the claimant has transformed from a contract of service for a fixed term to normal contract of service that was not for a fixed period of time, but based on contract of service like any other staff of the defendant. This also means that the claim of the claimant for payment of 9 months salary for alleged remaining period unexpired term of tenure has become ocioso, with the finding that the claimant's employment was properly terminated based on his written admission of the reason given for termination. The claimant, if he has to make any claim to be entitled to any claim, must show to the court he earned he earned those claims entitlement he is claiming based on instrument or law or terms and conditions of service. The claimant has submitted that having served the defendant for more than 3 years is entitled to pay off as provided for the term in the terms and conditions of service. Going by Exhibit CWC, CW1D, and CW1F1 to 18, Clause 5.0 of the terms and conditions of service has made it clear that a claimant employee who lost his job due to disciplinary action is not entitled to pay off. There is no dispute in the fact that termination of claimant's employment was predicated on misconduct. This shows that the claimant, by the paragraph 5.0a of the terms and conditions of service, is not entitled to any payoff. From all I have been saying above, the claimant has not made out any case to be entitled to any relief being sought. In other words, the claimant has failed in his duties of establishing his case. Same is hereby discountenanced. On the whole, the claimant has failed woefully to prove his case, and therefore he is not entitled to any of the relief being sought. The claimant's case lacks merit, and same is hereby dismissed. I make no order as to cost. Judgment is entered accordingly.
As the court pleases.
Yes, call the next case quickly.
Yes, my lord. Suit number NICN ABJ 120-2018 between Mr. Adebayo Ogunleye versus Stanbic IBTC Bank PLC. My lord, the parties are absent.
Okay. Any appearance?
Appearance for the defendant, my lord. Waiting for the plaintiff to announce appearance.
Yes, you can go ahead.
My lord, for the defendant, appearing is Kende Aino.
Kende Aino.
Yes, my lord. And appearing with me for the defendant, my lord. And appearing with me, my lord, is my colleague Utenge Okon. Utenge is spelled Utenge, my lord. Okay. And Okon is Okon.
Yes.
Defendant, my lord.
Sorry, my lord. Maybe, Lord. Lawrence Alabi is my name.
Yes. Lawrence Alabi.
Alabi, I humbly announce my appearance for the claimant. My appearance is for.
But are you appearing with you?
No, alone, my lord.
Are you appearing alone?
Yes, my lord. Alone with God.
Yes, we are all with him.
My lord, the matter is slated today for judgment, and
yes,
subject.
The judgment is ready. It's going to be read now.
We are grateful, my lord.
But I will omit some of the details, like the submissions of counsel and the rest.
As the court pleases, my lord.
Yes, the judgment goes like this. The claimant commenced this action bear a general form of complaint dated 26th day of April 2018, and the said complaint was amended on the 3rd day of April 2019 by the amended complaint and statement on oath. The claims of the claimants are as follows. One, a declaration. Well, I will also skip reading. You all have the release being sought by the
As God pleases.
Yes,
As
my
God
Lord.
pleases.
I will skip all the introductory part of the judgment.
Very well,
I
my
will also skip the submissions of counsel. I will go straight to the decision because of time.
As God pleases, my Lord.
When you get the hard copy, you will see, or you get the soft copy, you will see all the submissions of counsel and other introductory matters that have been captured in the judgment. Yes, this is the court decision. I have carefully considered the processes filed in this suit as well as the evidence adduced in proof of the position taken by each of the parties. I have equally examined the written addresses of parties and listened attentively to the oral submissions of counsel in adjudication. The defendant is the written address filed before the court formulated a sole issue for determination. However, the sole issue was further divided into two issues for resolution. The claimant on his part formulated three issues for resolution. In determining an action, the court and the parties are bound by the claim before the court and the pleadings of the parties. As the pleadings defines issues to be resolved by the court. The relief being sought are of a combination of declaratory, special damages, and general damages. It is right law that claim before the court is circumscribed by the relief being sought by the claimant before the court. And the claimant's duty is to adduce such evidence and establish his claim. And the court's duty is to ensure that relief are granted and no grant was not made. Gabriel H.D. versus Cable Metal Nigeria Limited. The counsel for the defendant, in opposing the claim of the claimant, argues that the claimant has not entitlement to release the court from the court because the claimant was dismissed from service and termination was dismissed from service and termination of claimant's employment was dismissed from service. Counsel insisted that the dismissal of the claimant was done in line with existing regulations. The claimant was never denied fair hearing. In fact, the claimant was given fair hearing for defend himself through the invitation extended to him to appear before the Judicial Commission. The claimant, on his own part, stated that sometime on or about 6th day of December 2014, there was a fraud articulated as the Governor branch of the defendant, where the claimant works and the matter was charged for, and the claimant was prosecuted at ST Chief Magistrate Court. There charged CR of 45 of 2014. The claimant's salary for 2014 was not paid for the year 2014 during the pendency of the criminal trial. While the claimant was still ongoing, the defendant, by letter dated 13th day of February 2015, purportedly invited the claimant to attend disciplinary inquiry at bank office in Lagos. Disciplinary inquiry at bank office in Lagos. However, the claimant solicitor wrote to the defendant informing it that it will not be wise for the claimant to testify in an inquiry over a matter that was already pending in court. That it will be wise to carry until the conclusion of the criminal trial so that the case will not be prejudiced. The acknowledged copy of the claimant's solicitor's letter dated the 5th day of February 2016 was tendered in evidence and admitted as exhibit. The defendant insisted, instead of heeding to the lawful advice given by the claimant's solicitor, went ahead and dismissed the claimant without affording the claimant fair hearing, as contemplated under the Constitution of the Federal Republic of Nigeria as amended. The claimant was called from his branch at Gwagwalada to come and seek a letter from head office, and when he arrived, he was given a copy of letter dated 23rd day of March 2016 titled Notification of Dismissal. The claimant stated following his wrongful dismissal, he was not paid his entitlement, no severance was paid to him, and his allowances and pension were also withheld. The claimant was eventually discharged and acquitted on 10th day of November 2017. See Exhibit I-1 to 9. The facts of this case are plain and straightforward, without any ambiguity. The narrow area of dispute is on alleged breach of fair hearing. The claimant's position is that, with the criminal trial hanging on his head, the defendant should hold his arms and allow the trial to be conducted before taking up the trial committee to try him for misconduct. For the defendant, there is no breach of fair hearing. The claimant was afforded opportunity of hearing, but refused to take advantage of the opportunity afforded him to explain his side of the story. Let me say here that in taking disciplinary action against an employee, that may lead to summary dismissal of employee, like in this case, more particularly allegations bordering on misconduct. The employer is enjoined by law, whether the employment is one that has statutory labor or that of ordinary master-servant relationship governed by common law, the employee must be given fair hearing. See the case of GB versus River State Civil Service Commission. In the case at hand, the facts as disclosed in the pleadings and under cross-examination, the claimant in this case was invited to appear before the disciplinary committee, but based on the advice of his counsel, the claimant shunned the disciplinary hearing. With shunned the disciplinary hearing, this was despite the fact that upon receipt of the claimant's counsel letter stating that claimant will not honor the invitation, the defendant rescheduled the hearing to another date and advised the claimant to honor the said invitation to appear before the disciplinary hearing on the rescheduled date. The claimant failed and neglected to give to the advice to honor the invitation by appearing before the disciplinary committee. If this scenario does not amount to affording claimant fair hearing, I do not know what will satisfy the claimant or what the claimant considered to be given opportunity for hearing. The claimant's reliance on the advice of his counsel by his refusal, despite all entreaties, to appear before the disciplinary hearing on the allegation level against him in Exhibit F1 to 2 and Exhibit BWG is fatal to the interest of the claimant. It is to be noted that counsel advice cannot serve as position of the law. It remains advice until sanctioned by law or affirmed by the decision of the court. In his attempt to prove that he has no hand in what he was accused of warrant taking criminal disciplinary hearing, it was argued on behalf of the claimant that the evidence of the defendant's witness under cross-examination has stated that the office of the defendant closed at 6 p.m. and the visitor of the claimant, his mechanic, did not enter the office, and that his laptop cannot work once taken outside the banquet hall. It's not conclusive enough to exculpate the claimant. The reason being that the defendant's witness is not an expert. Therefore, whatever evidence he gives is either a figment of his imagination or speculation or guesswork, which cannot be relied on in law. I am strengthened in taking this position, considering the entire evidence surrounding the circumstances. It is not in dispute that a fraud did take place on the 4th of December 2014, where a certain amount of money from the accounts of two customers of the defendant, Ren Oil and another, were transferred to some other accounts and the fraud was traced to have been perpetrated or carried out using ID belonging to the claimant's official laptop. This goes to prove that the evidence shows that the transaction cannot be done outside the banking hall with the claimant's laptop does not have good footage or legs to stand on. There is evidence that as at the time the incident occurred, it was around 7 p.m. when the bank had been closed and there was nobody in the banking hall. This has proved that the claimant's laptop can be used to conduct transactions even when the laptop was not in the banking hall. The claimant clinging to the assertion that the laptop cannot work outside the banking hall goes to nothing since there is no since there is no expert evidence to establish to establish otherwise. It is a fact of common knowledge which requires no proof that nowadays transactions can be done remotely using can be done can be done remotely using electronic devices such as mobile phones, laptops, desktops, and even on apps. It is equally not the law that an employee who has been hardworking or throughout his period of service has not been queried or suspended cannot be disciplined, or he has immunity from discipline whenever he was found to be wrong, whenever he was found to be on the wrong side of the law, or found wanting, or when he decides to violate the extant regulations. The claimant in his effort to prove absence of denial of hearing relied heavily on the letter of his counsel written to the defendant to the effect that because he is standing trial, he cannot attend any inquiry until after the criminal matter is finally determined by the magistrate court. This is because, according to claimant, he must always be present in the court during the criminal trial. This assertion without more is not enough to assist the claimant or to be a reason for him not to attend the disciplinary hearing. This is because the claimant who wants to avail himself of such an exercise had not shown to all prove to the court that the charges of criminal trial at the magistrate court was heard on day-to-day basis till it was concluded. He has also not shown that the date he was invited to appear before the disciplinary committee coincide with the date he was attending his criminal trial. The claimant also made heavy weather on the discharge of an acquittal of the claimant as per Exhibit F-129 as a proof of his innocence on the allegation level against him. Let me make it very clear that the mere fact that a court of law has discharged an acquitted claimant of any criminal charges cannot serve over the employer from taking any disciplinary action. The fact cannot cannot bar an employer from taking disciplinary action respecting those facts. See the case of Arrange versus First Bank PLC. Under the common law, all the defendant needs to do is to afford the employee an opportunity of being heard before exercising his power of summary dismissal. Even where the allegations for which the employee is being dismissed involve accusation of crime, it is not the requirement of the law that the employee must be tried first before a court of law. Insofar as the accusation against the employee is for gross misconduct, satisfies the rule of natural justice, or fair hearing, a person is a person likely to be affected directly by the disciplinary proceeding must be given adequate notice of the allegation against him to make representation in his own defense. All that will suffice. All that will suffice is for the complaint as formulated convey to the claimant the nature of the accusation against him. See the case of Yusuf versus Union Bank of Nigeria. See also the case of CCB Nigeria Limited versus Nwanko. In the case at hand, Exhibit F1 to 2, which is same with Exhibit BWG tendered by the defendant, convey to the claimant catalog of misconduct, which the claimant is being invited to appear before the disciplinary committee inquiry set up by the defendant regarding loss of funds by the defendant belonging to the two customers of the claimant Rain Oil and Parbot Breweries Limited. By the Exhibit B1 to 2 tendered by the claimant, which is same with Exhibit BWS tendered by the defendant, the counsel for the claimant categorically informed the defendant that the claimant having been arraigned before magistrate court to face criminal charges regarding the subject matter of the inquiry by the defendant, the claimant had been advised that the matter is sub judice and that it will be unlawful for the claimant to attend the inquiry. In the circumstances, the claimant will not honor the invitation to attend the inquiry by the Exhibit CWA and Exhibit BWB. The defendant wrote a reply to the defendant's solicitor stating that it will be erroneous to assume that the disciplinary inquiry to that the disciplinary inquiry and that the disciplinary inquiry was based on misconduct. Consequently, the date for the inquiry was rescheduled from 17th day of February 2015 to 17th day of March 2015. However, the refusal of the reclaimant to honor the invitation led to the issuance of Exhibit S1 to 2, a letter notifying the claimant of his dismissal from service of the defendant with effect from 23rd day of March 2015. It is clear from the above evidence that the claimant was notified of the allegation leveled against him and he was afforded opportunity to defend himself, but he chose to go by the advice of his counsel not to honor the invitation to appear before the disciplinary committee. The refusal of the claimant to honor the invitation to appear before the disciplinary committee goes to show that the claimant has no answer to the accusation contained in the letter of invitation. Therefore, the claimant cannot be heard to complain of lack of fair hearing. He was given opportunity to react, but rejected it. The claimant should therefore bear the brunt of his actions and not to blame the defendant for situations that he found himself in. The claimant and his counsel were wrong to insist of first facing criminal trial before appearing before a disciplinary committee. The law is now well settled that an employer has the right to discipline his employee for misconduct, notwithstanding any criminal allegation. The employer cannot be made to wait until the employee is dealt with in a criminal trial. See the case of Anna Sanjay versus Bank of the North Limited, reported in 2005, 8 Nigerian Upload Report 39, 28, 650. The law is right as authorities on this issue are generally agreed that the employee can be tried for misconduct. The disciplinary committee is not in connection. The disciplinary committee is not in connection with the employer. Is not in connection with the criminal trial. It was based on gross misconduct as this and not based on the criminal trial which the claimant was facing before the magistrate court. Therefore, the defendant has the right to try the claimant while the criminal case was pending. See the case of Salim versus Fujiroli Nigeria Limited. See also the case of ATIA Poly versus Minor. The Supreme Court has affirmed that now employer need not wait need not wait for conviction in a criminal allegation before determining the employment of an employee, as decided in the case of Arinze versus First Bank of Nigeria Limited and Olarewajo versus Afribank GD versus River State Civil Service Commission. The Court of Appeal also have similar decisions in the case of Idigbe versus NUT, UVN versus Chineye, Attorney General of Kwara State versus Ojulari, and Jubril versus Military Governor of Kwara State. The above analysis of the pleadings and evidence before the court clearly shows that the claimant has willfully failed to establish that he was denied fair hearing. If there is any denial of fair hearing, it was claimant himself that denied himself fair hearing by his rejection of the opportunity afforded to him to state his own side of the story. Therefore, the dismissal of the claimant from service did not infringe on any claimant's right, nor has it been done in contravention of any law. I found the dismissal properly done. There is no law preventing or prohibiting taking of disciplinary action against an employee. The law has long been settled that an employee has the right to take disciplinary action against his employee, notwithstanding the employee is facing or standing criminal trial. The discharge and acquittal of the claimant cannot prevent or render disciplinary action taken unlawful. Cannot render the discharge and acquittal of the claimant cannot render the disciplinary action taken against him as illegal or unlawful. I have deeply considered the submissions of counsel for both sides on the status of the claimant and the applicable terms and conditions of service governing the claimant's employment. The law is well settled that, except in employment governed by statute, where the procedure for employment and discipline, including dismissal of an employee, are clearly spelled out, any other employment outside the statute is governed by the terms under which the parties agree to be master and servant. Employment with statutory labor must be terminated in the way and manner prescribed by the relevant statute, and in any other manner of termination inconsistent therewith is null and void and obnoxious. But in other cases governed by agreement of parties, as in this case, and not by the statute, removal by way of termination or dismissal will in the form agreed be. Any other form cannot only wrongful termination or dismissal, but not declare such dismissal null and void. The only remedy is to claim for damages for that wrongful dismissal. This is based on the notion that no servant can be enforced by the court on unwilling master, even where the master's behavior is wrong. In the case at hand, having found claimant dismissal to be in order, the claimant is not entitled to any of the relief being sought. In the circumstances, the termination of the dismissal of the claimant from service of the defendant is valid, having been made after claimant has been afforded opportunity of hearing, but on his own volition rejected it. In view of my finding above, the case of the claimant has no merit. I hereby dismiss it in its totality. I make no order as court. Judgment is entered accordingly.
As the court pleases.
Lord, we thank you for the rather insightful judgment, and we truly appreciate your Lordship's conclusions, and most importantly, such a very lucid and educative judgment for that matter. We are indeed most grateful.
Right. Yeah, welcome. Thank you very much, Council. We have come to the end of the virtual sitting. So the administrator will end the virtual sitting. Thank you very much. Have a nice day.
Thank you, my lord.
Thank you, my lord.
No, thank you.